in the Westminster Magistrates Court between Government of the United States of America, requesting state, and Julian Assange, defendant.
It is now possible to stand back and emphasize that both the prosecution and the extradition request are extraordinary, unprecedented, and politicized in a number of striking ways.
Firstly, Mr. Assange's extradition is not being sought for any of those ordinary extradition crimes, such as murder, drug trafficking, but for the extraordinary crime of espionage, universally recognized as a political offense. And extradition for political offenses is barred under Article 4.1 of the Anglo-US Treaty, the only legal foundation for the request under international law. Secondly, the prosecution itself is unprecedented in the United States because it seeks to criminalize obtaining and publishing information relating to national security. Thirdly, the very unusual history of this prosecution points to a clear political motivation for the belated bringing of charges that occurred as long ago as 2010 and 2011 by the Trump administration in 2018.
Fourthly, this prosecution has been accompanied by a series of extraordinary executive acts of undermining the rule of law. Finally, there is evidence that Mr. Assange's human rights will be threatened upon extradition.
The actual request issued by the US fundamentally misrepresents the facts in order to bring this case within the bounds of an extradition crime.
Extradition is barred under Section 81A of the Extradition Act 2003, the 2003 Act, by reason of the political motivation of the request and because it is in fact made for the purpose of prosecuting or punishing him on account of his political opinions. Assistant United States Attorney Kronberg did not submit himself to cross-examination by the court and denied the defense the opportunity to challenge his assertion that the Department of Justice was not motivated by political reason.
Moreover, we submit that extradition is barred under Section 81B because it exposes Mr. Assange to the real risk of discrimination on grounds of both his political and his foreign nationality at every stage of the criminal justice process in the U.S. Section 9.
It would further expose him to a flagrant denial of his Article 10 rights to freedom of expression.
Extradition is barred under Section 87 of the 2003 Act because it would expose Julian Assange to a complete denial of his right to a fair trial under Article 6, Part C.
Extradition is barred because it would expose Julian Assange to inhuman and degrading treatment contrary to Article 3 of the European Convention on Human Rights. That is because of the potential imposition of a wholly disproportionate sentence for the conduct alleged in this case, amounting, in effect, to a life sentence.
Extradition should be refused under Section 91 because it would be unjust and oppressive to extradite Mr. Assange by reason of his mental condition and the high risk of suicide.
WikiLeaks publications exposed outrageous, even murderous wrongdoing, including war crimes, torture, and atrocities on civilians. All witnesses attested to the fact that they saw the revelations and publications as part of a political project to promote democratic accountability and expose how war was being waged in Afghanistan and Iraq, and that states were abusing their powers under a cloak of secrecy.
According to the evidence given in the court, the essence of Julian Assange's political opinions, which have provoked this prosecution, are summarized as follows.
Julian Assange's belief in transparency and accountability inevitably brought him into conflict with the Trump administration.
Essentially, what he stands for represents some kind of threat to normal political endeavor. Julian Assange described US policy in relation to the International Criminal Court, ICC, as a case study in the use of diplomacy to undermine international institutions.
The reason for his prosecution was that he believed that without transparency, there was really no effective democracy, and in putting these beliefs into action, had challenged the legitimacy of the government secrecy system.
Those beliefs and actions inevitably brought him into conflict with successive US administrations, but particularly the current one, which explains why WikiLeaks was called a hostile non-state intelligence service, and Assange an anti-American ideologue. Finally, targeting him for exposing war crimes is part of a wider ideological agenda of this administration, to punish and deter non-US nationals from exposing US war crimes.
Successive US administrations have identified Julian Assange as a political actor seeking to influence US policy.
Indeed, the political character of Julian Assange's conflict with the US motivated the Ecuadorian government to grant him political asylum.
Professor Chomsky states, "He has performed an enormous service to all those who treasure freedom and democracy and demand the right to know what their elected representatives are doing. His positive impact on the world is undeniable. The hostility it has provoked from the Trump administration is equally undeniable."
The actual conduct alleged against Julian Assange is summarized as follows. WikiLeaks and Julian Assange received and published evidence exposing war crimes, torture, and atrocities on civilians in the Iraq and Afghan wars, and the practice of rendition for torture and interrogation of detainees. Quote, Mr. Assange's vision was that the digital age might allow a new kind of whistleblower and leaking of information that could redress some of the growing imbalance between citizens and governments, unquote.
The prosecution have repeatedly tried to suggest that this prosecution has nothing to do with the collateral murder video. Yet, the rules of engagement were received and published as an integral part of the collateral murder publication, precisely to demonstrate that the helicopter strike was unlawful and that there had been a cover-up by the US military.
Assange said at the launch of the Collateral Murder publication in 2010, if those killings were lawful under the rules of engagement, then the rules of engagement are deeply wrong. Dean Yates' evidence relates how, viewing upon the Collateral Murder video, I immediately understood that the US military had lied to us.
The Guantanamo detainee assessment briefs provided evidence that Guantanamo detainees had been the subject of prior rendition and detention in CIA black sites before their arrival at Guantanamo, and that their detention was arbitrary. In fact, the WikiLeaks revelations served to expose the total unreliability of the justifications put forward for the detention of the prisoners.
The Afghan war diaries revealed what seemed to be serious war crimes and included 1. The existence of a black unit operating kill or capture lists and hunting down targets for extrajudicial killings. 2. The killing of civilians, including women and children.
3. The role of Pakistan intelligence in arming and training terrorist groups. 4. The role of the CIA in the conflict, including participation in strikes and night raids.
The Iraq War Diaries exposed 1. Systematic torture of detainees, including women and children, by Iraqi and U.S. forces, and a secret order by which U.S. ignored the abuse and handed detainees over to the Iraqi torture squad.
2. Helicopter killings, including of insurgents trying to surrender.
3. Details of 15,000 previously unreported civilian deaths, including those of women and children, showing that the U.S. government was hiding the full civilian cost of the Iraq War.
4. Details of 23,000 previously unreported incidents in which Iraqi civilians were killed and their bodies were found.
The Iraq War Diaries attracted worldwide opprobrium for torture and war crimes committed by or acquiesced to by the U.S., leading to calls for proper investigations by Amnesty International, the UN Special Rapporteur on Torture, and the UN Commissioner for Human Rights.
The U.S. diplomatic cables exposed evidence of 1. CIA and U.S. forces' involvement in targeted extrajudicial killings in Pakistan.
2. Deliberate killing of civilians.
3. Pressure exerted on European countries by US officials not to prosecute CIA personnel suspected of involvement in crimes. 4. The Yemeni government holding Yemeni citizens in prison on behalf of the US, despite their own government investigation finding no evidence they were involved in terrorist acts.
5. The US, at the behest of the CIA, was spying on the UN Secretary-General, UN Security Council members, and foreign diplomats at the UN in New York, in violation of international law. 6. US support for certain authoritarian regimes despite their human rights record.
7. The corruption of the Ben Ali regime in Tunisia, which the US publicly supported, but behind closed doors did not support his continued leadership. Amnesty International described the WikiLeaks publications as a catalyst for the Arab Spring and a, quote, watershed year when activists and journalists used new technology to speak truth to power and push for greater respect for human rights. When repressive governments faced the possibility that their days were numbered. 8. The UK, quote, put measures in place to protect US interests by limiting the scope of the public inquiry into the UK's involvement in the Iraq War, fueling further public debate about the US-UK relationship.
9. The U.S. had systematically sought to undermine the ICC. 10. U.S. war crimes in Iraq, including the killing of civilians. 11. The State Department had made knowingly false representations to Congress about the Colombian government and military's human rights record, despite evidence of the killing of civilians.
Significantly, the Department of Justice under President Obama decided not to prosecute Julian Assange in respect of the revelations. Equally significantly, the DOJ under the Trump administration was pressured into reversing the Obama administration's approach and prosecuting Julian Assange, despite the implications for the constitutional protections of the First Amendment.
For 7 years under Obama, no action was taken against Julian Assange and WikiLeaks in respect of the Manning leaks.
Extradition is only now being sought for the receipt and publication of materials provided to WikiLeaks by Chelsea Manning. All the relevant conduct occurred between 2010 and 2011 and was known about at that time. Yet Mr. Assange's prosecution and the first extradition request were not begun until December 2017. A superseding indictment was not issued until 23 May 2019. Moreover, a second superseding indictment, dated 24 June 2020, is still principally focused on the Manning links.
The decision made under the Obama administration not to prosecute Julian Assange in 2013 was because of what has been described as the New York Times problem. The prosecutors concluded that charging Assange would have been in violation of the First Amendment.
Attorney General Holder himself had already made clear in 2013 that any journalist who's engaged in true journalistic activities is not going to be prosecuted by this Justice Department. Holder clearly saw no distinction between Julian Assange and a journalist.
The prosecution of Julian Assange, initiated in December 2017, was the result of the conflict between Assange's actions and the incoming administration. In response to WikiLeaks publications of the US diplomatic cables, President Trump called for the death penalty or something for Assange. He also denounced Obama's commutation of Manning's sentence, describing her as a traitor who should have never been released from prison. When he became president, he effectively declared war on journalists and leaks, and even went on to call for the execution of journalists.
The hostility to Julian Assange was evidenced by the escalating public statements by administration officials condemning him from 2017 onwards, the dramatic ratcheting up of the charges against him, and the way in which he was subject to surveillance in the embassy, expelled from the embassy, and then deprived of his own legally privileged documents. Most of all, it is demonstrated by the reversal of the approach adopted under Obama and the initiation of an unprecedented prosecution for the receipt and publication of documents, plainly in the public interest. To this end, the prosecution has sought to distort the facts in order to present a prosecution for political offenses as a prosecution for ordinary crimes, and provide the veneer of a legitimate prosecution, in response to this accusation of politicization.
The prosecution asserts that they are not influenced by political considerations. However, the overwhelming evidence is that under the Trump administration, there has been repeated and unprecedented interference by the president and his political appointees with the normal criminal justice process.
In the prelude to this prosecution, President Trump had repeatedly referred to the press as the opposition party and the enemy of the people. He denounced the news media as a whole as sick, dishonest, crazed, unpatriotic, unhinged, and totally corrupt, and attacked them as purveyors of fake news.
President Trump met with FBI Director James Comey in February 2017 and suggested putting a head on a pike and putting journalists in jail. This is not surprising, given that WikiLeaks had called for President Trump's tax returns to be leaked prior to his election and within days of his inauguration.
Julian Assange and WikiLeaks also attracted the enmity of the CIA by publishing Vault 7, the largest ever publication of confidential documents on the agency, in March 2017. Other publications had angered and exposed the CIA as engaging in unlawful activities around the world. In 2015 and 2016, WikiLeaks also revealed that the NSA had been spying on high-level government officials in France, Germany, Italy, Japan, and Brazil, as well as the United Nations and European Union. These publications upset the relations between the US and its allies. Significantly, from March 2017, WikiLeaks also campaigned against President Trump's appointees, Mike Pompeo and Jeff Sessions, and Gina Haspel, the head of the CIA.
His revelations and continuing work also posed a threat to their geopolitical agenda, which is why his prosecution, based on no new evidence, was now advocated by the Trump administration, led by spokesmen such as Mike Pompeo, then director of the CIA, and Attorney General Sessions.
Pressure was then put on prosecutors by the Attorney General to bring an indictment, despite scepticism from career professionals about its legality and open objections from prosecutors directly involved in the case. Significantly, CNN reported in April 2017 that prosecutors have struggled with whether the Australian is protected from prosecution by the First Amendment, but now believe they have found a path forward.
This political pressure led to the criminal complaint of computer misuse being made against Julian Assange on the 21st of December 2017.
The prosecution was not only novel, it was also selective, since other US-based organisations that publicised the same materials, such as Cryptome, and the Internet Archive were left untouched.
There followed the initial indictment in March 2018 for conspiracy to commit computer intrusion and computer espionage. This remained sealed at that stage as the administration laid further plans to have him removed from the embassy before the indictment was publicly unsealed in 2019. No explanation has ever been given for bringing forward this indictment in 2018, nor for the latter addition in 2019 of the 17 further charges of espionage.
At the same time, Julian Assange's conversations with his lawyers were being constantly monitored by a private agency, UC Global, acting on the instructions of US intelligence and for their benefit. Moreover, the contents of their electronic devices were unlawfully copied.
There then followed a concerted effort by the Trump administration to ensure that Julian Assange was expelled from the Ecuadorian embassy by a process of pressuring and bribing Ecuador into expelling him, so as to make him available for extradition. The plan was to ensure that he was prosecuted for the Chelsea Manning disclosures and expelled from the embassy to face prosecution.
Julian Assange was finally expelled from the embassy on the 11th of April 2019 and arrested.
His privileged legal papers were also seized and conveyed to Ecuador, from where they were later transferred to the United States.
Then, in May 2019, a dramatically new superseding indictment was brought, which now charged Julian Assange with 17 further charges under the Espionage Act. But resort to the Espionage Act for a publisher was both unprecedented and sinister. The new indictment charged Assange with publication of state secrets and dramatically ratcheted up the scale of the charges, the pressure on him, and the potential penalties. He faces up to 175 years in prison if convicted of all offenses in the superseding indictment.
There was no new evidence to justify the introduction of these new charges, and that two of the prosecutors disagreed with the charges because the DOJ did not have significant evidence or facts beyond what the Obama-era officials had when they reviewed the case.
This decision to prosecute for publication of state secrets was unprecedented. This was stressed by witness after witness. One witness stated that the series of charges related to mere receipt and possession of Manning materials seek to criminalise national security journalism itself and spell the end of such public interest journalism.
The U.S. has offered absolutely no legal precedent for this indictment.
The second superseding indictment, dated 24 June 2020, appears to have come in response to the criticisms of inadequacy in the prosecution case. Thus, it artificially manufactures a conspiracy extending beyond 2013 and into 2015 so as to justify prosecution, despite the 2013 decision and the long delay under Obama. Furthermore, it seeks to depict Julian Assange as a continuing threat to the U.S., to link him to Edward Snowden, and to present him as the leader of a wide-ranging conspiracy to gain unauthorized access to government computers.
The means of employment and the targeting of Julian Assange further show that he has been made the object of exceptional extra-legal measures.
First, the meetings between Mr. Assange and his lawyers were recorded by private security agents acting on behalf of the US whilst he was sheltering in the Ecuadorian embassy. During this time, his lawyers were under physical surveillance by these agents, and the offices of one of them were broken into. Then, he was evicted from the embassy after the intervention of the US. Finally, his confidential papers were illegally taken from him at the request of the US.
All this points to a clear disregard for the rule of law and a gross violation of Article 22 of the Vienna Convention of Diplomatic Relations, which guarantees the inviolability of diplomatic premises, and it took place in this country, which is relevant to the question of abuse.
Then steps were taken to ensure that he was expelled from the embassy by a process of bullying and bribing Ecuador into expelling him, to make him available for extradition. The history, which involves Ecuadorian officials, UC Global, and President Trump's inner circle, includes evidence showing the sharing of the product of surveillance of Julian Assange in the embassy with President Trump's inner circle. UC Global Director David Morales is charged with illegal spying on Julian Assange's lawyers and doctors. Morales was employed by Sheldon Adelson's organization, Las Vegas Sands. Adelson is Trump's main benefactor.
Further evidence of the bad faith and abuse of power was the approach to Mr. Assange by Republican Congressman Dana Rohrabacher in August 2017. Mr. Rohrabacher visited Julian Assange and discussed a pardon deal in exchange for personal assistance to President Trump in the inquiry then ongoing concerning Russian involvement in the hacking and leaking of the Democratic National Committee emails.
The court heard that President Trump was aware of and approved of the meeting with Mr. Assange to discuss the proposals for a deal.
The prosecution further involves a fundamental violation of Article 4.1 of the Anglo-US Extradition Treaty, which expressly prohibits extradition for political offences.
It is our submission that this court has jurisdiction to stay an extradition request on the grounds of abuse of process, where the request is in breach of the terms of the treaty, which provides the only legal basis for extradition to take place under international law.
To extradite Mr. Assange in reliance on the very treaty which governs the legality of his extradition whilst disregarding the protection contained therein against extradition for a political offense, would violate the rule of law and render an extradition both arbitrary and inconsistent with the Article 5 of the Convention.
Julian Assange is protected from extradition because espionage is a pure political offense, and Article 4.1 expressly protects from extradition for political offenses.
The prosecution submit that the treaty is not directed at pure political offenses, but only at relative political offenses, that is, ordinary crimes committed for political motives. However, their reasoning simply focuses on the fact that most of the case law decided in the Anglo-American context prior to the 2003 treaty deals with relative political offenses.
In any event, the conduct alleged against Mr. Assange plainly qualifies as political offence of and by reason of the alleged and avowed intentions of Julian Assange.
The courts have widened the concept of a political offense to include any ordinary criminal offense which has plain political purpose and intention.
The prosecution claims that Mr. Assange's conduct does not even qualify as constituting a relative political offense, but the test for treating an offense as a political offense in the relative sense includes actions taken to effect an alteration in governmental policy.
For all these reasons, it is submitted that there is jurisdiction for the court to stay these proceedings on the basis that extradition for political offences is an abuse of process, given that it would violate the express terms of the Anglo-US Extradition Treaty.
For the purposes of Section 81A, it is necessary to show that the motivation behind the prosecution and the extradition request is primarily to punish and deter the defendant for his political opinions.
An individual exposes whole-scale abuse and war crimes by a state, and thereby attracts prosecution for the very act of such exposure, is entitled to the protection of Section 81A and also to the protection of Article 4 of the treaty.
The prosecution do not dispute that Julian Assange's political opinions motivated his conduct. They simply seek to present the case on the basis that he is being prosecuted for ordinary criminal conduct, which they characterize as hacking and the exposure to danger of individuals whose names were published.
They submit that there was no earlier decision not to prosecute, and that the experts are wrong to base any opinions on that assertion. Their position is undermined by the following. 1. They do not explain the long delay in prosecution between 2010 and 2017. 2. They do not contradict the assertion that a decision was taken in 2013 under the Obama administration not to prosecute. 3. They provide no explanation of the decision-making process, despite the fact that memoranda would clearly exist recording the various decisions taken. 4. They do not deny that there were express protests and resignations by career prosecutors involved in the case when the first superseding indictment with new allegations of espionage was brought in 2019. 5. There provided no explanation for the late prosecution in 2017, the introduction of the first superseding indictment in 2019, and the second superseding indictment in August 2020. Finally, they have not answered the expert evidence of political motivation from expert witnesses by any independent evidence of their own. Nor have they submitted the only witness deployed by them to rebut the allegation of political motivation to have his claims tested in cross-examination.
The chronology of the case itself, the reversal of the Obama administration's approach, the novel and unprecedented legal basis of the prosecution, and the misleading nature of the evidential case presented all together point to a politically motivated prosecution, and for all of these reasons, Mr. Assange invokes the protection of Section 81A.
Turning to Section 81B, the test is whether there is a real risk or a reasonable chance that Julian Assange will be prejudiced or discriminated against at his trial, at the sentencing stage, or in the manner of his subsequent imprisonment by reason of his political opinions and or his foreign status.
It is submitted that there is such a risk for the following reasons. 1. Mr. Assange has been publicly denounced by the most high-ranking public officials, including the President, because of his political opinions. 2. The US are taking the position that he has no First Amendment rights as a foreigner. 3. Mr. Assange's political status will also result in him being held in especially harsh prison conditions. 4. The intelligence agencies, including the CIA, will have considerable influence on his fate. In this context, it is relevant that the CIA has already indicated its intention, through its former chief, Mike Pompeo, quote, to become a much more vicious agency, end quote, and clearly will not change overnight under any new administration. Finally, Julian Assange's trial, sentence, and subsequent detention will all take place in the context of a criminal justice system that lends itself to political manipulation.
There are substantial grounds for believing Mr. Assange's extradition will carry a real risk of an Article 7 violation for the following reasons. 1. Key components of the offence for which his extradition is sought are so broad, vague and ambiguous that they do not meet the minimum standard of accessibility and foreseeability required by Article 7. 2. The Computer Fraud and Abuse Act is similarly broad, vague and vulnerable to political manipulation. 3. Mr. Assange could not reasonably have foreseen that the acts which he is alleged to have committed would have involved the commission of an offence.
The current law is derived from the Espionage Act 1917, the sweeping breadth of which was drawn to catch not just espionage in the traditional sense, but also any individual who by their opposition to US involvement in World War I would inject the poison of disloyalty into matters of state. Expressly introduced by the then president to be a firm hand of stern repression, its indefinite language allowed the Act to be used as a vehicle for oppression and designed to be catch-all.
It was described by scholars as incomprehensible, with incredible confusion surrounding the issue of criminal responsibility for collection, retention, and public disclosure of defense secrets. Even its proponents had to be content to rely upon, quote, prosecutorial discretion to ensure its provisions were not enforced politically.
For example, the modern classification system allows the executive, rather than Congress, to decide the scope of the phrase national defense information by determining what information is classified.
Many studies have found that government very often overclassifies information such that information whose disclosure could not reasonably be expected to cause damage to national security is classified.
Thus, the mere fact of classification is not a reliable indicator that disclosure could reasonably be expected to cause injury to the interests of the United States.
The provisions of the Computer Fraud and Abuse Act dealing with national defense information are taken directly from the Espionage Act and contains identical language as the Espionage Act. Necessarily, therefore, it suffers from similar breadth that enables the Espionage Act's enormous malleability. The provisions of the Computer Fraud and Abuse Act dealing with national defense information are taken directly from the Espionage Act and contains identical language as the Espionage Act. Necessarily, therefore, it suffers from similar breadth that enables the Espionage Act's enormous malleability.
Its most prior notorious use for the prosecution of co-founder of Reddit, Aaron Swartz, who later committed suicide as a result, was accepted by the Justice Department to have arisen in part due to Mr. Swartz's political beliefs, which, like those of Mr. Assange, included advocacy for open information.
Its use against Mr. Assange in this context is no less profoundly troubling.
All defense witnesses to whom this issue was put accepted that the Act has survived various vagueness challenges over the years. But all told, this court that vagueness is situation specific. And because the Act has never been applied to the press before, no existing authority assists with whether its operation in that context would be held constitutional.
An individual must be able to know from the wording of the relevant provision, and, if need be, with the assistance of the court's interpretation of it, what acts and omissions will make him criminally liable.
A 2013 study by Columbia University found that thousands upon thousands of national security-related leaks to the media have occurred. Leaking to journalists has become routinized in Washington.
While leakers have been prosecuted, albeit selectively, generally senior government officials from whom most leaks probably originate have not.
In reality, the Act is so imprecise and broad and so selectively applied as to allow the executive and prosecuting authorities to define what conduct is criminal under the Act on a case-by-case basis, such that a crime under this Act is a matter not of law, but of political will and design.
In the US, newspapers have published excerpts of secret or classified documents ever since the nation's founding, without prosecution, the examples of which are legion.
The prosecution of Mr. Assange crosses a new legal frontier.
It breaks all legal precedents.
The indictment of a publisher for the publication of secrets under the Espionage Act has no precedent in US history, and in particular, there has been no known prior attempt to bring an Espionage Act prosecution against a non-US publisher.
An authoritative review of the Espionage Act considered its terms as posing, quote, the greatest threat to the acquisition and publication of defense information by reporters and newspapers, end quote, and as, quote, a loaded gun pointed at newspapers and reporters who publish foreign policy and defense secrets, end quote.
This court heard unchallenged evidence that one category of persons who had never therefore been the subject of prosecution in the US is journalists who obtain and publish state secrets.
There have been prior isolated political threats to prosecute reporters for publishing classified information, usually those at odds with the respective administration, but these have consistently failed on grounds relating to press freedom.
In these, quote, politically charged cases, unquote, the desire of the government to prosecute journalists always, quote, founded on First Amendment grounds, and the long-standing precedent that publishing secret records is not a crime.
In 2010 to 2011, the relevant time under consideration, it was wholly unforeseeable that such an indictment could or would be issued against a member of the press for obtaining, receiving, or publishing leaked classified information.
Likewise, Cryptome and other websites that published the unredacted cables ahead of WikiLeaks were never prosecuted. The unredacted cables hosted by those US-based sites are still hosted there, and Cryptome confirms that the US has never requested their removal.
The importance of press freedom is such that Article 10 even imposes positive obligations on states, including, for example, the protection of journalists against violence.
Whatever the potential scope of the UK's Official Secrets Act, it has likewise never been deployed to prosecute, much less convict, the act of obtaining or publishing, as opposed to leaking, classified information. The core reason for that is the same as pertains in the USA under First Amendment principles. It is fundamentally inconsistent with, and a flagrant denial of, press freedoms. In this jurisdiction, this prosecution would be, and extradition here facilitates, a flagrant violation of Article 10.
The indictment seems to criminalise the soliciting, receiving and publishing of national defence information, which from a journalistic standpoint essentially boils down to news gathering. It has triggered an outcry from human rights and civil liberties organisations, but most of all from journalists, not because of affection for Assange, but because, as one wrote, it characterises everyday journalistic practices as part of a criminal conspiracy.
Not only is the conduct the subject of this indictment, quote, the essence of journalism, unquote, WikiLeaks' steps to force the world's disparate media to cooperate together in this publication process was, quote, a game-changing moment in the history of journalism.
In the absence of any sensible precedent for this prosecution, and consistent prosecutorial practice over 230 years, the US response has been to attempt to suggest that this case is, quote, different. For the purposes of the First Amendment and Article 10 of the Convention, because 1. Assange conspired with or assisted Manning in her illegal activity of leaking. Or 2. Assange engaged in separate criminal activity in attempting to crack a passcode hash with Manning. Or 3. WikiLeaks and Assange deliberately put lives at risk by disclosing unredacted materials, which it is said takes this case outside the protections of the First Amendment. Or, if all that fails, 4. Mr. Assange is beyond the scope of the First Amendment because, quote, foreign nationals are not entitled to protections under the First Amendment.
Every witness this court heard rejected every one of those theories. They are unsound and unprincipled as a matter of U.S. law. More importantly, they are irrelevant to the court's Article 10, Section 87 analysis.
The theory of liability underpinning the indictment is that it is unlawful for Mr. Assange to ask, encourage, aid, or abet a serving soldier to break the law by disclosing classified information. Every witness to whom this theory was put told this court that it represented a completely misconceived view of the First Amendment.
As every witness explained, to reason that because the whistleblower herself commits an Espionage Act offense by leaking classified information to the press, anyone, including the press who encourages, facilitates, solicits that act is legally liable as a conspirator, and that crime is a theory of criminality liability without foundation or precedent. It would criminalize news gathering. It would criminalize the mere act of having this material with you. It would criminalize every single reporter who has ever received any document, whether they asked for it or not, from a source that potentially broke the law.
The First Amendment protection does not vary according to the identity of the publisher or whether the publisher profited from the publication.
No journalist has ever been prosecuted under the OSA for the act of obtaining or receiving or publishing leaked information. Undoubtedly, because much more stringent considerations apply to the prosecution of journalists, both in terms of the protections of the law and public interest.
Next, the U.S. suggests that the passcode hash allegation is such an example of prohibited separate criminality. But as Mr. Feldstein testified in court, trying to help protect your source as a journalist is an obligation. So if that becomes criminalized, if that becomes conspiring, then most of what journalists do, investigative journalists on national securities, would be criminal.
It is inconceivable that the ECTHR would regard law breaching undertaken in order to protect the whistleblower's anonymity as capable of taking journalistic actions outside the protection of Article 10.
The prosecution has finally attempted to draw a distinction between Mr. Assange and other journalists on the basis that his extradition is not sought, quote, in respect of any responsible journalistic treatment of the material provided by Chelsea Manning.
In reality, if the publisher's entitlement to the First Amendment protection, or indeed protection under Article 10, turned on whether the government believed the publisher had exercised editorial discretion appropriately, the First Amendment's protection would be unavailable precisely in the cases publishers needed it most.
Unsurprisingly, therefore, no authority is cited in support of this bizarre theory.
Neither is it a prosecutorial theory that withstands any historical scrutiny, here or in the US. Whether or not anyone considers Julian Assange a journalist is beside the point. He was engaging in journalistic behavior. He was acting as a publisher.
There are numerous examples of such conduct having occurred in the US without suggestion of criminality or prosecution.
The notion that U.S. criminal jurisdiction attaches to foreign conduct, such as in play here, but not the First Amendment, does not likewise attach, is a surprising one, to put it mildly. Yet, it is the view of the DOJ that Mr. Assange, quote, has no First Amendment freedoms because, quote, he is not a U.S. citizen, end quote. Whatever the scope of application of the First Amendment, Article 10 is not nationality specific. So even if the First Amendment were inapplicable to Mr. Assange in this case, then all the more reason for this court to act under Section 87. No U.S. court will apparently enforce or protect Article 10's principles in this case. That would be a paradigm flagrant denial of Article 10. It is an especially significant breach where the conduct in question was undertaken from within the sphere of protection of the Council of Europe, i.e. the UK. Extradition in these circumstances will not only retroactively nullify the lawful exercise of those Article 10 rights within the Council of Europe, but will be on terms that envisage that the U.S. court will consider it against no similar protections.
Assuming that the First Amendment will be considered at all by any prospective trial judge, then this court should conclude on the compelling evidence it has heard that the First Amendment will prevent this prosecution.
The US efforts to suggest that the First Amendment, Article 10, should not apply are in fact undermined by significant and deliberate factual misstatement with regard to each of its three central allegations, namely, 1. The allegations that Manning's disclosures were causally solicited by the WikiLeaks draft most wanted list is flatly contradictory to the evidence given in Manning's court-martial and publicly available information. 2. The passcode hash allegation was contrived knowing, yet concealing from this court, that it was flatly contradictory to the evidence given by US government witnesses before the Manning court-martial. 3. The allegation that WikiLeaks deliberately put lives at risk by deliberately disclosing unredacted materials is also factually inaccurate.
All of these assertions are in reality deliberate factual misstatements. That knowingly false allegations are brought is not only indicative of the political motivation lying behind this request, but actionable in their own right.
A prosecutor or judge requesting extradition could be held to be abusing the court's process where he knew he had no real case, but continued to seek extradition for another motive and accordingly tailored the choice of these documents accompanying the request.
The evidence also shows that the draft most wanted list correlation allegation that Mr. Assange was involved in the original data theft is completely misleading.
The request separately alleges that Mr. Assange assisted Manning to steal classified documents by agreeing to help to decrypt the passcode hash value.
The catalogue of messages that were recovered betray no discussion whatever of the use to which the decrypted hash value might be put, much less any plan to disguise Manning's access to documents or cover her tracks. They do not even suggest that the hash related to a government computer.
Moreover, the encrypted hash value which Manning shared was insufficient to be able to crack the password in the way the government have described. This would be known to anyone with basic technical knowledge. Even the government's own expert witness in the court-martial stated that that was not enough for them to actually be able to do it.
Nevertheless, it is boldly alleged that decrypting the passcode hash value was being attempted by Assange and Manning to allow the latter to log onto military computers under a name that did not belong to her, to make it more difficult for investigators to identify Manning as the source of disclosures.
The evidence summarised above shows that the passcode hash conspiracy allegation is completely misleading.
A further allegation made by myriad US officials is that Mr. Assange is no journalist because he published classified materials without redaction, and so created a grave and imminent risk to people he named through publication of the war diaries and the cables. The government's arguments have been devoted almost entirely to this issue.
But the allegation is known to the US government to be completely and utterly misleading. The truth is that WikiLeaks was in possession of the material for a considerable period before publication and went to extraordinary lengths to publish in a responsible and redacted manner, and that unredacted publication was undertaken by third parties unconnected to WikiLeaks.
The U.S. government knows well, but has withheld from this court, that this release of unredacted materials came about as a result of a series of unforeseeable events outside of the control of Mr. Assange, or indeed WikiLeaks.
WikiLeaks did so in circumstances where, quote, the full database was already downloadable from hundreds of sites.
It is wrong and unfair to accuse Mr. Assange of having published the unredacted, unclassified cable.
More importantly, republication of material already in the public domain is not a criminal offense in this jurisdiction.
Any possible exposure to harm was caused by the predicate actions of Cryptome, Pirate Bay, etc., in releasing the unredacted cables.
The U.S., of course, has a long history of making deliberately vague and exaggerated assertions of potential harm posed by publication of classified materials, which invariably transpired to be overwrought and untrue. This case is no different. No actual harm occurred.
In summary, this is a paradigm example of Zakshevsky abuse. It is neither permissible nor lawful to misdescribe lawful republication of publicly available material as unlawful conduct when it is not.
The Zakshevsky jurisdiction enables this court to ascertain the true facts and to feed those true facts into the dual criminality machinery of Section 137. When done here, no offending emerges.
The WikiLeaks publication disclosed US involvement in torture and war crimes. They sit at the very apex of public interest disclosure. The prohibition against torture is a peremptory norm of international law. War crimes and rendition are grave breaches of international law and a profound affront to the international legal order. They are also notoriously difficult to detect and expose because of the secrecy that surrounds them. The subject matter of the publications is currently the subject of criminal investigations of the CIA before the ICC.
Attempts by the U.S. government to obtain impunity for its war crimes are a separate, egregious violation of international law. WikiLeaks cables also evidence the lengths the U.S. government subsequently went to pervert such investigation.
Likewise, in Italy, the only country in the world to investigate and convict CIA agents for extraordinary rendition, the cables revealed direct evidence of secret and relentless pressures exerted by U.S. diplomacy to prevent the extradition of the 26 U.S. nationals convicted, and appears to have resulted in pardons being issued to them by various administrations.
The cables similarly demonstrated US interference with other rendition investigations in Spain and Poland.
As detailed above, but purposefully excised by the extradition request, the release of the 2006-2008 versions of the US-Iraq Rules of Engagement was integral to the release to the public of the collateral murder video.
The US Army helicopter video footage is as disturbing now as it was in 2010. It shows the killing of 11 people by a US helicopter in Baghdad on the 12th of July 2007, a full version of which the US government had refused to release, instead issuing flat denials of wrongdoing, such that at the time it was impossible to prove that all those who died were unarmed civilians, including 2 Reuters journalists, despite compelling witness evidence. It disclosed acute criminality, which the US government sought to actively cover up and which could never have been established through more traditional journalistic efforts.
The release of the video was picked up by thousands of news organisations worldwide, sparking global outrage and condemnation. It will be hard to overstate how important it was.
The Guantanamo detainee assessment briefs provided evidence that Guantanamo detainees had been the subject of prior rendition and detention in CIA black sites before their arrival at Guantanamo.
We are talking about criminal offenses of torture, kidnapping, renditions, holding people without the rule of law, and, sad to say, murder. But the US government thought it was okay for them to keep that secret.
The briefs also documented the nature of the evidence relied upon by the US to justify the detentions, including the repeated use of information and informants known to be unreliable or to have been tortured, and in some cases the detention of persons known to be innocent. The disclosures were really important because the world did not know the allegations.
The use of evidence obtained by torture and arbitrary detention of this nature are international crimes of colossal proportions.
The Afghan war diaries revealed what seemed to be war crimes.
The Iraq material covers the 6-year period from the 1st of January 2004 to the 31st of December 2009, exposing numerous cases of torture and abuse of Iraqi prisoners by Iraqi police and soldiers, as well as proof of the U.S. government's involvement in the deaths and maiming of more than 200,000 people.
The Iraq War Diaries attracted worldwide opprobrium, leading to calls for proper investigations into the conduct of Allied troops.
The public has a right to know about the existence of such violations, and states have a concomitant duty not to conceal them.
UK law concerning Official Secrets Acts recognizes and gives effect to these core principles. The disclosure of otherwise secret evidence of war crimes or gross human rights violations is necessary to avoid imminent peril of danger to life or serious injury. It is necessary to expose and prosecute criminality which sits at the very apex of the international legal order. That is why, for example, the Statute of Rome contains protections for those, like Mr. Assange, who reveal evidence of crimes within the jurisdiction of the ICC.
Contrary to the position in England and Wales, the U.S. offenses with which Mr. Assange has been charged contain nothing approaching a prosecutorial requirement to disprove necessity. No such defense is to be found within the statute, and the U.S. government does not suggest such a defense exists.
The Espionage Act is, in fact, indifferent to the defendant's motives and indifferent to whether the harms caused by disclosure were outweighed by the value of the information to the public. The computer intrusion offence is no different.
As summarized above, Mr. Assange's conduct involved the exposure of war crimes of the highest order, which actions the U.S. government at the time had gone to great lengths to disguise. Some of those crimes are currently under investigation by the ICC. The materials he revealed have been of international importance in shifting U.S. government policy away from the use of rendition and torture.
They have proved necessary to prevent both danger to life and serious injury. They have enabled courts and tribunals around the world to bring justice to those affected. Mr. Assange's actions helped change a culture of impunity for torture and war crimes, and even contributed to the ending of war.
If extradited, no US court will consider necessity as part of its determination of guilt or innocence at all. The risk faced by this court is that Mr. Assange will be convicted for conduct which was necessary. This court is the only court that will ever consider the substantive issue of necessity. Extradition can only therefore occur where this court has actively considered the merits of the issue and is satisfied beyond all doubt that it cannot possibly avail on the facts.
Under the 2003 Act, the fact that WikiLeaks were engaged in the revelation of state crimes also renders their conduct political, within the meaning of Section 81A.
Where a state is involved in criminal activity, as the US was here, opposition to state criminal acts is a political action.
These concepts are embedded in the case law of England and Wales and constitute imputed political opinions.
The case law on the interpretation of the Refugee Convention also makes it clear that a person who exposes criminality in a state in which criminality is endemic is expressing a direct political opinion. A challenge to the criminality or corruption in such a state is inherently political, as it is a challenge to the way in which the organization of that society operates.
The principle applies even where the state in question disavows the criminality revealed.
WikiLeaks was founded a few years after Bush administration had launched its war on terror in the Middle East, at a time when public information about engagements in Iraq and Afghanistan bore little resemblance to the situation on the ground.
As Mr. Assange himself explained publicly in August 2011, WikiLeaks had exposed the everyday squalor and barbarity of war, information which was kept secret by the US military. His motivation was manifest. Quote, "If wars can be started by lies, peace can be started by truth."
Daniel Ellsberg draws parallels between the revelations he brought about in the leaking of the Pentagon Papers and their impact upon the approach to the Vietnam War with the WikiLeaks exposures. He considers the latter to be the most important truthful revelations of hidden criminal state behavior in US history.
Much of the information disclosed by WikiLeaks was frequently no secret to Iraqis or Afghans, or foreign journalists who all knew very well about who had been killed and by whom. But its value lay in the fact that such incidents could not otherwise have been proven.
WikiLeaks publications, in fact, played a part in bringing a formal end to US military involvement in Iraq by evidencing in an irrefutable way particular criminal acts on the part of the US military, which had been deliberately covered up, and from about 2011 to the present time, there has been much greater caution among Western countries, specifically the United States and the United Kingdom, in the willingness to go to war at an early stage. I think that this is to a considerable extent due to WikiLeaks.
Amnesty International credited WikiLeaks with sparking the Arab Spring via these releases, including as a catalyst for the Tunisian revolution.
One has to see WikiLeaks also as a type of archive, a record, and that it had been widely used by a wide variety of international relations and war scholars to fill in the detail, if you like.
The documents likewise continue to be used by national courts providing redress for the myriad human rights abuses they revealed.
For his disclosures in the public interest, Mr. Assange was awarded inter alia the Sydney Peace Medal, the Walkley Award for Most Outstanding Contribution for Journalism, Australia's Pulitzer, and has been nominated year on year for the Nobel Peace Prize.
As stated above, U.S. law provides no power for any U.S. court to consider any sort of public interest jurisdiction.
US law provides that the accused may not challenge in court the classified status of documents and information.
War crimes, such as those revealed by the WikiLeaks, are the primary subject matter of the ICC.
On 20th November 2017, ICC prosecutor Bensouda submitted to the pre-trial chamber a request to open a formal investigation against the US in respect of the war crimes committed by US troops and by the CIA in Afghanistan and elsewhere in connection with the war on terror in Afghanistan.
The criminal complaint against Mr. Assange materialized in December 2017, days after the prosecutor's investigation request.
It is reasonable to infer that the two events were linked.
Torture is banned by international law, and no derogation is permitted, even in times of armed conflict or terrorist attacks. This is a prohibition under customary and treaty law, specifically in the UN Convention Against Torture, the International Covenant on Civil and Political Rights, and Common Article 3 of the 1949 Geneva Convention.
Second, under Articles 5 to 8 of the Campaign Against Torture and under the Rome Statute, torture amounts to a war crime or a crime against humanity, and, quote, it is the duty of every state to exercise criminal jurisdiction over those responsible for international crimes.
Third, failure by states to initiate a prompt criminal investigation into allegations of torture is itself a de facto denial of the rights under the CAT and the ICCPR, as well as customary international law. Failure by states to do so eviscerates the prohibition against torture, and itself violates Article 3 of the Convention.
The U.S. government has long sought to evade the jurisdiction of the ICC for war crimes committed by the CIA. In the wake of events of 11 September 2001 and the U.S.'s actions subsequent to it, President Bush informed the UN Secretary General that the U.S. did not intend to ratify the Rome Statute or recognize obligations under it. The U.S. then put in place bilateral Article 98 agreements over 100 ICC states to ensure other states would not arrest or turn over U.S. personnel to face ICC prosecution.
The US then passed legislation in 2002 which actively prevented US cooperation with the ICC, and further amendments threatened cuts in aid to foreign states that would not sign Article 98 agreements. Aid cuts were in fact implemented against 7 ICC states and 2 intergovernmental programs.
In November 2016, after a decade-long preliminary investigation, the ICC announced that there would soon be a decision taken on whether to investigate the US for war crimes in Afghanistan. The US responded by saying it was not warranted or appreciated, given the US's own robust system of accountability.
Quite the opposite is true.
Even when the individual perpetrator of a crime was clearly identifiable, no one has been prosecuted by the US. Presidential clemency has been issued in every case in which prosecutions have been attempted or contemplated for acts of criminality in Afghanistan.
The ICC has jurisdiction over war crimes and crimes against humanity committed on the territory of ICC members states, which include Afghanistan and the Eastern European countries, which hosted the CIA black site and will act when national authorities do not generally pursue cases.
On 25th September 2018, President Trump stated at the UN General Assembly that the US considered that the ICC had no jurisdiction, no legitimacy, and no authority, and he would never surrender America's sovereignty to an unelected, unaccountable global bureaucracy, but rather embrace the doctrine of patriotism to defend America from global governance, as well as other new forms of coercion and domination.
On the 15th of March 2019, Mr. Pompeo announced that visas would be denied to all ICC staff investigating US personnel and their allies in Afghanistan, specifically stating that the US would be prepared to take additional steps, including economic sanctions, if the ICC does not change its course.
The US then did revoke the ICC prosecutor's visa.
2 weeks later, on April 19th, 2019, the ICC did change its course, despite finding a reasonable basis to believe that members of the US armed forces and the CIA committed the war crimes of torture and cruel treatment, outrages upon personal dignity and rape, and other forms of sexual violence, and finding that these incidents fall within the jurisdiction of the court as a war crime, the ICC pretrial chamber nonetheless refused the prosecutor's request to open an investigation as not in the interests of justice.
However, on the 5th of March 2020, this decision was reversed and an investigation authorized by the ICC Appeals Chamber.
In the wake of that decision, the threats made by the US quickly materialized. First, on 17th of March 2020, Mr. Pompeo, then director of the CIA and one of the subjects of the ICC investigation, issued thinly veiled threats to specific ICC staff members.
In short, the unchallenged evidence shows that the US is prepared to go to any lengths, including misusing its own criminal justice system, to suppress those able and prepared to try to bring its war crimes to account and protect those accused of them. Mr. Assange was one of those persons. The timings of the US actions in this case, when set against the parallel progression of the ICC investigations that Mr. Assange helped bring about, are no coincidence.
The evidence of a number of experts supports the submission that there is a real risk that Julian Assange will be exposed to a flagrant denial of justice, both at trial and at the sentencing stage, and that he faces a sentence of somewhere between 20 years and a full 175 years, which the government could easily ask for.
It was made clear that there would be pressure put on him to plead because of his massive potential sentence and the likelihood that he would be subjected to SAMs, special administrative measures. One expert further confirmed that his sentence could be increased by references to allegations of which he had not even been convicted.
The system will be skewed even further against Julian Assange, because this prosecution will be located in Alexandria, Virginia, from which a jury pool comprised almost entirely of government employees and/or government contractors is guaranteed.
He will be liable to be tried on the basis of evidence obtained from Chelsea Manning by inhuman treatment and torture.
In addition, his trial will be seriously prejudiced by the public denunciation of him made by serious administration officials from the President to the present Secretary of State and successive Attorney Generals. This intemperate public denunciation violates the presumption of innocence, as established by the European Court.
For these reasons, Mr. Assange's extradition would violate Article 6 of the Convention.
There is a real risk that Julian Assange will be exposed to inhumane treatment in the United States.
That is firstly because there is a risk that he will be subjected to a disproportionately long sentence for his actual conduct. The sentence could be as long as his whole life, and certainly is likely to be between 30 and 40 years. Now, a sentence of this length is not just permitted but strongly indicated by the guidelines because of the way in which the case has been prosecuted and the way in which the two superseding indictments have been framed. This creates a real risk of a massively disproportionate and wholly inappropriate sentence, given that the conduct now alleged was not even deemed criminal by the DOJ under the Obama administration.
But more particularly, the real risk of inhuman treatment arises by reason of the fact that Julian Assange, a psychologically vulnerable person suffering from depression and autism spectrum disorder, is most likely to be subjected to conditions of solitary confinement, both at the pre-trial and post-trial stages, in spite of his mental vulnerability.
Those very facts, further, make his extradition unjust and oppressive by reason of his mental disorder.
The evidence is clear that such a regime precipitates mental breakdowns and heightens the risk of suicide even for mentally stable prisoners, and that such a regime is inappropriate and dangerous for mentally ill inmates. That is the conclusion of the report of the Center for Constitutional Rights and of the 2014 Amnesty Report, Entombed: Isolation in the U.S. Federal Prison System.
Mental health treatment and care in these regimes fails to comply with minimum Article 3 protections.
This is significant because there is clear evidence from both defense and prosecution experts that Mr. Assange suffers from serious clinical depression and requires medical help.
There is a real likelihood that Mr. Assange will be detained in administrative segregation and even under special administrative measures at the pre-trial phase. He will effectively be subject to solitary confinement, denied association, and have limited contact with the outside world. And he will receive no specialist mental health care.
Turning to the position post-trial, the U.S. acknowledges that there is a real risk that Mr. Assange will be subjected to a SAMS regime at ADX Florence, Colorado. That is particularly so given that one of the most notorious espionage cases, and he has already been singled out by the Attorney General for a particular attention with the two superseding indictments brought under William Barr.
The U.S. government submits that these regimes would not contravene Article 3. But both the European Court and the English High Court have held that detention and conditions of isolation, such as the U.S. provides under SAMS, will not breach Article 3 if it is appropriate for the individual case, is not long-lasting or indefinite, is subject to review, and is not imposed on those suffering from mental disorder.
Moreover, both the European Court and the English High Court have refused extradition as inhuman or oppressive by reason of mental disorder in cases where the likely conditions in U.S. detention were found to be wholly inappropriate for the particular requested person by reason of their mental disorder.
Both the English High Court and the European Court of Human Rights have expressed profound concerns about the potential inhumanity of conditions in so-called administrative segregation in the U.S. prison system, amounting effectively to solitary confinement, particularly for those with special mental vulnerability.
We are dealing here with an extremely vulnerable person with a long history of clinical depression, a diagnosis of Asperger's syndrome, and an established risk of suicide. Detention in such conditions for Julian Assange would be the height of inhumanity.
There is clear evidence that he will not receive the necessary medical care, either pre-trial or post-trial.
Prisoners detained at ADX Florence spend from 22 to 24 hours per day locked alone in their cells. They are not permitted any association with other prisoners and they are not permitted any group activities at all. The court heard evidence that the former warden of ADX Florence had described the condition as not built for humanity, that being there, day by day, it's worse than death. It is significant that he had worked for the BOP for over 20 years and was the warden of ADX Florence between 2002 and 2005. So he spoke with some authority on this subject.
So the court can see that there is clear evidence of a real risk that Julian Assange, despite his confirmed diagnosis of depression and his liability to deteriorate in conditions of isolation, will be held in ADX Florence in H Unit in conditions of isolation, that his detention there will be indefinite, that it will be subject to no proper review, and that it may go on for many years without him receiving proper medical treatment. That of itself is enough to render his extradition a breach of Article 3.
The prison regime described above, the accompanying isolation and the life-threatening effects are likely to be imposed on Mr. Assange arbitrarily, and despite the fact that he is alleged to be neither a violent offender or a terrorist.
For the reasons set out above, it is submitted that earlier cases relied on by the prosecution do not address the particular type of situation here or the evidence that is now available on the prison conditions that Julian Assange will face in the year 2020 and the effects that these prison regimes will have in this particular case. The subjection of Julian Assange to these draconian and dehumanizing regimes will inevitably increase the high risk of suicide that already exists.
On the 25th of September 2020, the court exercised its management powers to exclude the evidence of Professor Craig Haney, dated the 23rd of September 2020.
Julian Assange accepts that the court was seeking to exercise a case management power. However, the court is invited to take account of the plain fact that the assertions of Lukefield and Kronberg about the regime at ADX Colorado, and particularly the regime in H Unit, are directly contradicted by the leading expert on solitary confinement in the US, who has actually visited and toured ADX Florence on a number of occasions and has shown that the criticisms made by expert witnesses are well founded. When it comes to considerations involving the risk of inhuman conditions of detention, the court will obviously be concerned by the evidence of government witnesses who cannot be challenged in cross-examination, that was produced very late in the day, and that was, within a short space of 20 days, strenuously criticised by Professor Haney. That bare fact cannot, it is respectfully submitted, be ignored.
Section 91 affords a protection from extradition, where extradition would be rendered unjust or oppressive by reason of physical or mental disorder.
In this context, Mr. Assange relies upon the evidence of expert psychiatrists and psychologists who deal with his history of clinical depression and trauma and the high risk of suicide if he is extradited to the US.
This is a classic case for invoking the jurisdiction exercised by the High Court in the case of Love pursuant to Section 91 of the 2003 Act. That case provides this court with a precedent for protecting a person suffering from mental illness from extradition on grounds of oppression on three alternative grounds. Firstly, because it would be oppressive to extradite someone suffering from mental illness, where the very fact of extradition and removal from family contact would expose them to a high risk of suicide. Secondly, because it would be particularly oppressive to extradite where the underlying illness and the risk of suicide would be exacerbated by inappropriate conditions of detention that the requested person would inevitably face in the US. Thirdly, because it would be oppressive and inhumane to expose the requested person to harsh conditions of detention, including segregation, where they were suffering from mental illness and would inevitably deteriorate mentally, irrespective of whether they would actually commit suicide.
All the defense expert evidence satisfies the test laid down in Turner v. United States and subsequent cases for discharge under Section 91 in cases of suicide risk.
Moreover, there is a very real risk that Julian Assange will be driven to take his own life by the very prospect of extradition or the very fact of being extradited to the US, given the lengthy detention and inappropriate and inhuman conditions that he knows await him there.
Finally, irrespective of suicide risk, the fact that he is a person suffering from undeniable depression, which has a proven capacity to deteriorate under stress and in conditions of isolation, means that extradition to face the conditions of detention, both pre-trial and post-trial isolation described in the sections above, also makes it oppressive to extradite him.
In dealing with the question of oppression under Section 91, the court is entitled to look at all factors, including the nature of the charges.
Finally, the court must consider the passage of time and whether to apply the protection against extradition where it has become unjust and oppressive by reason of the same. The position of Mr. Assange is as follows.
Firstly, there clearly has been a long passage of time. No explanation has been given by the U.S. for bringing the charges as late as December 2017 in respect of conduct known as long ago as 2010.
If it really is self-evident that Mr. Assange should be the subject of prosecution, the court is still left with the question as to why there has been such a long delay in prosecution Mr. Assange for publications that took place in 2010-2011.
That is relevant because culpable delay on the part of the state seeking extradition is a factor to be taken into account in deciding whether it would be unjust or oppressive to extradite now.
Even if the decision to prosecute now was presumed to be justified, then the long delay does nonetheless require some proper explanation. Absent explanation, the court is entitled to conclude that there was culpable delay in bringing the prosecution for these offences, which the US now say are very serious, when all the relevant factors were known at the latest by 2012.
Secondly, there has been an earlier considered decision not to prosecute in 2013. The fact of an earlier inconsistent decision not to pursue a prosecution was recognised to be a highly significant factor in determining injustice and oppression in the leading case of Kharkis versus Cyprus, where the requested person's belief that he was covered by an amnesty and the long delay in initiating proceedings against him, taken together, were held to render it oppressive as well as unjust to extradite.
The fact of an earlier inconsistent decision not to pursue a prosecution was recognised to be a highly significant factor in determining injustice and oppression in the leading case of Kharkis versus Cyprus, where the requested person's belief that he was covered by an amnesty and the long delay in initiating proceedings against him, taken together, were held to render it oppressive as well as unjust to extradite.
These proceedings, upon an indictment issued in March 2018, superseded in May 2019, began in April 2019 and were squarely focused for their first 12 months on the 2010 Manning disclosures.
On 24th June 2020, 4 months after opening submissions were heard, and 10 weeks before the eventual stage of the extradition, hearing was listed to commence. That changed. The U.S. issued a press release signaling that the indictment has been superseded again. This third iteration of the indictment added a series of new factual allegations unrelated to the Manning allegations. concerning allegations of general encouragement, solicitations to persons to steal U.S. classified information.
On the 29th of July 2020, 5 weeks before the extradition hearing, the US served the new indictment on the court.
On 12th August 2020, 3 weeks prior to the extradition hearing, the US issued a fresh extradition request dated 17th July 2020, founded upon the new indictment. That request was executed on the first day of the extradition hearing on 7th September 2020.
On 21st August 2020, the U.S. served its revised opening note with an addendum which explained the import of the new indictment. It said that the addendum particulars in the second superseding indictment constitute the conduct upon which this court must now determine that an extradition offense is made out under Sections 78 and 137 of the 2003 Act.
Despite requests, the U.S. have offered no explanation for the absence of these allegations from the first or even second indictment, where the allegations date from 2009 and could have been prosecuted at any time in the last decade, including prior to the emergence of the Swedish proceedings. Neither has there even been explanation for why this new request arrived a year and a half after their commencement, 6 months after opening submissions, days after the final defense evidence deadline had passed, and just days prior to the third listing of the extradition hearing.
The inexplicably late arrival of these new allegations placed the defense in an impossible position. On the one hand, and self-evidently, the defense were not in a position to respond to these fresh factual allegations in the time afforded by their late service. In a Part 2 context, it would be extraordinary for a court to commence a hearing within weeks of a fresh extradition request of this kind being made, not least of all in the circumstances where Mr. Assange was in custody without access to legal visits and with access to physical materials only via post. To be able to address these new allegations and the circumstances surrounding them would require the defense to seek adjournment of the proceedings for very many months.
On the other hand, adjournment of these proceedings and prolonging the defendant's custody was equally clearly unfair, particularly as there was no imminent prospect for in-person access to the defendant to be restored. The defence declined to make that application because the court possesses ample other powers to address the unfairness.
The power to excise conduct from a request is a long-standing one, and one which was approved by the House of Lords.
On the 7th of September, this court ruled that the power to excise was constrained in law to operate only within the consideration of statutory bars.
By virtue of the late arrival of these new allegations, this court does not have access to the information necessary to reach informed or reliable answers to the various statutory and non-statutory questions it must ask itself. Absent being able to know the whole position, the court cannot fairly answer any of those questions, and adversely to the defense, the new allegations cannot therefore be the subject of any extradition order and must be excised.
Despite its 7th of September ruling, this court has declined to admit evidence outlining the areas of defense evidence that would have been adduced had time permitted.
But, in accordance with that ruling, the defense position remains that this court must excise the new allegations from the request because the court is not in a position to answer, fairly, one or more of the statutory or non-statutory questions. For example,
the new allegations are obviously aged and date from 2009. As stated above, the US have offered no explanation for the decade-long delay in bringing these charges.
On its face, the delay here was culpable.
This court has also heard that the U.S. request fails to disclose that the 2012 trial referred to above took place before Suffolk Crown Court. If it had merit, Mr. Assange could and should have been prosecuted for this additional conduct years ago, alongside his so-called conspirators, and that prosecution would have occurred in the UK.
The existence of that prosecution is a clear indicator that extradition is barred by reason of forum considerations.
By deliberate omission, this court is being provided with a singularly distorted picture of the cogency and efficacy of the allegations leveled in the new indictment. These cumulative omissions are, in their own right, the sort of non-disclosure which courts in the UK have previously found to warrant discharge.
The request is also materially misleading in its description of Mr. Assange's conduct. But, like all of the above statutory and non-statutory challenges, because of the circumstances in which these new allegations have arisen, the defense is hindered in its ability to place the full and complete picture before the court.
For all the reasons set out above, it is submitted that this extradition request should be refused. That is because it is politically motivated, it is an abuse of the process of this court, and it is a clear violation of the requirements of the Anglo-US treaty that governs this extradition. It exposes Mr. Assange to the real risk of an entirely unforeseeable prosecution under a capricious extension of the law, and to a trial and sentencing process that constitute a flagrant denial of justice. It further exposes him to prejudice and discrimination by reason of his political opinions and foreign nationality, and to the virtual certainty of conditions of imprisonment that are both inhuman and oppressive. Finally, this unprecedented prosecution constitutes a flagrant denial of his right to freedom of expression and poses a fundamental threat to the freedom of the press throughout the world.